Good morning, ladies and gentlemen. As you can see, we are 6. One of our colleagues has been taken ill, and as we speak, he's being attended by a doctor. So because of the pressure of time, we have to go on without him. So we will start as we planned yesterday. Mr. Ngatia, I don't know whether it's you starting or Mr. Nasir. Can you please start?
Yes, my Lord Chief Justice and Judge of the Supreme Court, I will start for the third respondent, and will take a maximum of an hour.
You remember that you have 3 hours?
Yes, my Lord, I remember, but my chairman also wants to address the court, so.
Yes, Mr.
Yes, my lords. I've just been called by our lead counsel, my learned friend, senior counsel James Orengo, and the information I have, my lords, is that we are having challenges in compliance of the court order that was issued yesterday in terms of access to the IEBC servers. So my learned friend, Mr. Orengo, has requested me to address the court and inform the court that he will be here in the next 20-30 minutes, and we'll seek that once he comes, we kindly request the court to interrupt my learned friend's submissions to enable us make a report on that non-compliance of the court order that was issued yesterday. So we'll be seeking that courtesy. And that has already been communicated to the court. There is a letter that was written to the registrar of the Supreme Court, and it was received yesterday, today, 29th of August. And it gives details of the non-compliance from the IEBC. Thank you.
Very well. We will hear whatever observations that will be made when Mr. Orengo comes.
Much obliged.
My lords, before my learned friend goes away, I saw some papers being passed to the judges. Courtesy would have had it the other way around. First he passes to us to have a look before he passes to the court.
I thought they had been passed already to...
No, they haven't. At any rate, not for the third.
My Lord, I can pass that to my learned colleague. Yeah, as I said, they have just been filed in court this morning.
Give a copy to all counsel,
Yeah,
Mr.
Copies are being circulated, my lord.
Mr. Mugen, are they enough to go around?
Yes, they are enough. They are enough.
Yes,
yeah.
pass them around so that by the time when Mr. Orengo comes,
Yes.
everybody is on the same page.
Yeah.
Yes.
Much obliged, my lord. Thank you.
Sabri Nasir? Yes, my Lord. My Lord, in my address to this honorable court this morning, I will be addressing 5 different issues. But before I do that, my Lord, I would like to highlight 3 defining features that preceded this election, that defined this election of 8th August 2017. My Lord, the first one, and this we capture in our affidavits, is that in 2016, as a prelude to this election, the 2 petitioners drew a line on the sand and said that unless the entire commission, which is the first and second respondents, are replaced, they will not participate in elections. And my Lord, in compliance, or acceding to that, the entire country acceded to that, and in January, the entire commission of the first and second respondent was shown the door on the insistence of the petitioners. My Lord, emboldened by that victory, the first and second petitioners instigated a wide-range change in the law. The entire electoral law was as a result of that changed to their satisfaction. And my Lord, the third phase is that they did a litigation on a scale. It was actually on an industrial scale. The litigation on an industrial scale in which they litigated each and every aspect of the electoral law to ensure that the election is conducted as they demanded and required. For example, my Lord, they litigated the Al-Burai printing. They litigated an allegation that the president will deploy the army. They litigated on KPMG and the audit of the report. They litigated on the alternative complementary system under Section 44. My Lord, those three events show that the election of 8 August 2017 was done as the petitioners demanded. They were on the driving seat, my Lord. My Lord, having said that, let me address the 5 substantive issues I will address this honorable court. And my Lord, the first one is, whereas Article 140 and 163, 3A of the Constitution provide both the jurisdictional and the procedural platform for invalidating a presidential election, where can this court find the substantive law to invalidate a presidential election? My Lord, whereas Article 140 and 163, 3A of the Constitution provides both the procedural and the jurisdictional platform for this honorable court to invalidate a presidential election, where can you find the substantive law for invalidating a presidential election? Nobody has told you that, my Lord. Not the petitioners, not the first and second respondents. And I will show you, my Lord, that the only place you can find the substantive law to invalidate a presidential election is that you deconstruct Article 140, or what I call a reverse engineering of Article 140, and you will find the substantive law to invalidate a presidential election in Article 38, 2A. In other words, the only way you can invalidate the presidential election is to hold that the exercise Kenyans did on 8 August 2017, pursuant to Section 38, 2A, was invalid exercise.
Section or article?
Article 38, 2A. In other words, my Lord, election is a negative invalidation of the right to exercise a political right under Article 38, 2A. My Lord, the second issue I will address you on is in our local jurisprudence, what is the place of Raila Odinga versus IEPC 2013? The second, my Lord, is in our local jurisprudence, what is the place of Raila Odinga versus IEPC 2013 case? And is there any need to revisit or depart from the various findings this honorable court made in that decision? My Lords, the third issue I will address before this honorable court is the place of stare decisis and precedent in the electoral regime in this country, and in particular, my Lord, whether interpretation of the Constitution is binding to this court, notwithstanding Article 163(7). In other words, my Lord, can you depart from a constitutional interpretation, notwithstanding that the Constitution says that you can depart from your various decisions? My Lord, I will draw a distinction when you interpret either a statute or a common law, and when you interpret the Constitution. And I will try to persuade you that when you interpret the Constitution, you may not depart from it in a subsequent decision, notwithstanding what Article 163(7) says. My Lord, the fourth issue I will address you is what are the circumstances in which this court can invalidate a presidential election, on whose omissions and transgressions, can this court invalidate a presidential election? And my Lord, the answer to that may surprise many, and I will show you that in 99% of the cases, you can only invalidate a presidential election on the transgression of the voter who has exercised his will under Article 38(2)(1). It's only the transgression of the voter who has exercised his will under Article 38(1). Maybe 1% you can 1% is IEBC, if there's a transgression, 1%, because, my Lord, this election I will show you, as I will show you, my Lord, is all about the voter, the person who exercises his sovereign will. My Lord, lastly, but not the least, and in a very, very summary and cursory manner, I will take you through the petition that's before the court. I will go through the structure of that petition. I will take you through the form, the substance, the pleadings, and I will show you, my Lord, why I consider that petition a piece of science fiction. My Lord, let me start with the first one. My Lord, the first issue is an anchorage of a presidential petition in both its constitutional and doctrinal foundation. My Lord, it's my humble submission, my Lord, that an Article 140 just gives you the procedural platform. And my Lord, Chief Justice, to the credit of this court, when you published the 2017 presidential petition rules, introduced Rule 8, which for the first time really sets out 5 grounds upon which a presidential election can be invalidated. And my Lord, when you look at that and the petition, you will find that it's only ground 1 and ground 3 that this petition can be premised on. My Lord, I say that Article 140 is a reverse engineering of Article 138. And why do I say that? Because, my Lord, for this court to invalidate a presidential election, or for this court to appreciate that a presidential election petition has been brought out, we have to retrace our steps backward. And when we retrace our steps backward, my Lord, you will find that it is the events of 8 August 2017 when 17 million Kenyans went to the polls that brought about this result, or this court case. So it is the election, it is the exercise of the sovereign will of the people in casting their votes for their political leaders that has brought this event. So, my Lord, it is Article 38(2), that choice of Kenyans to decide who will be their leader, that brings about this election petition. It's not about the winning, or it's not about that the third respondent has been declared the winner that brings us here. No. My Lord, the winning of the third respondent is the consequence of the sovereign choice Kenyan voters made pursuant to Article 38(2). In fact, my Lord, the third respondent is a nominal respondent in this matter. This case is about the choice made by both the 8.2 million votes he got, the 6.4 million Raila got. That 15 million votes that was cast on 8 is what is being challenged in this court. The entire 15 million votes, the votes they cast. For the petitioners to succeed, this court must agree that those 15 million votes that were cast on 8 August don't count. It's not about whether IEBC officers signed some forms. It's not about whether President Uhuru did. It's not about all those things. It is about the 15 million votes. For you to overturn the decision, you must tell them that on 8 August, when you 15 million Kenyans came, you made some mistakes here and there, and we consider as a court that your votes will not count. That is the task you have, my lord. So, my lord, it's my humble submission, my lord, that the court needs to undertake a paradigm shift on how an Article 40 petition is approached. And that, my lord, you can only do by finding fault with the voter and say that your vote on that day does not count. So, my lord, when this court is adjudicating of a presidential petition like it's doing this morning, under Article 40 petition, the fulcrum, the very foundation, the focal point is that we are dealing with the voter, not with any other person. And we are dealing with the voter on the premise that every citizen has the right to a free and fair election based on universal suffrage and the free expression of the will of the electors. My lord, my learned friends referred, or my learned friends for the petitioner said that we are dealing with an Article 81. My lord, if you look at even Article 81, which actually buttresses the submission I'm making, Article 81 creates what I call a hierarchy of principles. And it is not by accident, it's by design. That Article 81 starts with the electoral system shall comply with the following principles. A, freedom of citizens to exercise their political rights under Article 38. That is a fortification. It solidifies my submission that this actually is all about the voter who voted on 8 August. And that is why in this hierarchy of principles, we start with the freedom of citizens to exercise their political rights under Article 38. So, my lord, we must never lose sight of the fact that this petitioner, the two petitioners, when they come to this court, they are challenging that right. And my lord, that's why I say this case is about a negative invalidation of a political right under Article 38. You must find, for you to invalidate this election, that Kenyans were not entitled to exercise their political right as they did in Article 38. In other words, that right, the political right, is what you are negativing. It's not a case, my lord, of saying that President Uhuru Kenyatta was not elected. No, that's not what is before you. What is before you is you must find, for you to find that the election was not conducted, you must find that Kenyans, the 15 million who voted in August 8, were not entitled to exercise their political right under Article 38. And the honors, as I will show you later on, my lord, the burden of proof, even the standard has to shift. Because the petitioner has to satisfy you that a person who exercises his right under Article 38 was not entitled to do. And that is the only way you can invalidate this election. So, my lord, and I said, my Lord, that we need a paradigm shift. Previously, we used to see this as a gladiatorial contest between the winner and the loser. No, it's not. It's not a contest between Raila and it's not a contest between the petitioner and the third respondent. It may look nice for the public viewers that this is, a gladiatorial contest between the two big players. No, my Lord, this is a right-centric dispute. It is a dispute that is centered on the political right of the individual. We need to shift, my Lord, this from a contest of political supremacy and see that really what is at the substratum of a dispute in a presidential election is a right that was exercised. So, my Lord, I pray that this court impresses a right-oriented approach, which is premised on Article 38, and not a result-oriented approach, which shows that the third respondent won this contest. And, my Lord, that needs a lot of caution from this court. That's an argument, my Lord. I will just plead that you hold it with, as Anton Scalia famously said, that some arguments you hold it with a belt and a suspender. Because a suspender may not be enough, or a belt may not be enough, although at times it's enough. But to be sure that it holds, you use both belt and a suspender, my Lord. So, my Lord, as I will show you later on, that it is very important that the approach you take, my Lord, is not about whether IEBC did certain omissions or not in validating these elections. And, my Lord, let me give you an example of, a typical Kenyan setting, a herdsman, for example, from Mandera, who doesn't even speak English or Swahili. He comes to a polling station. He votes with an assistance of one of the officials. He casts his vote. He may not understand the philosophical foundation of all these things, but he understands that he is making a choice. Then he walks out of that polling station and goes back to his cows or camels. My Lord, can that choice of that herdsman somewhere in Mandera be invalidated because an officer did not stamp some of the forms when he filled it? Can we invalidate such a right? Can we invalidate such a basic foundation of that right, of an illiterate Kenyan who exercised his right, who walked out of a polling station? But because one of the agents of the candidates did not sign, we say, no, that man has not voted. My Lord, that will be a travesty of justice, and that's not what this Constitution is all about. My Lord, let me go to the second point. What is the local place, or what is the place in our local jurisprudence of Raila Odinga versus IEBC 2013, my Lord? My Lord, to the credit of the court, and I have expressed many times my disagreement with this court on certain issues, especially its jurisdiction. But, my Lord, when it comes to our electoral law or the jurisprudence created by this court, especially starting with the Raila case, followed by Peter Munya case, Zekia Obado, Nadif Jama, and Kidero, this court has expanded the regime of electoral law like no other courts I know. You have solidified, you have settled the law, and the principles of election law in this country are so settled, so certain, so firm, that this court must be given credit for that. But, my Lord, in the Raila case, this court have addressed many issues, and it addressed it in a very, very proper manner, my Lord. It settled the law on important subjects of the law, like the burden of proof, the standard proof, rejected votes, and even the issue of judicial restraint. And, my Lord, yesterday one of my learned friends raised the issue of judicial restraint. But when I submitted on the issue of judicial restraint, it's not about the court abdicating its Judicial restraint is not about the court abdicating or laying its pen. No. Judicial restraint is the court following the law, exercising its jurisdiction as prescribed by the law. That's what I meant by judicial restraint, my lord. But my lord, Raila versus IEBC 2013 was unfairly attacked, not because of the jurisprudence espoused there, but because of the result the court reached. And that is natural because of the way the country was divided. 40-something% were not happy with it, 50-something% were happy with it, and that's natural. But my lord, the attack the court faced, from NGOs, or what my Lord Justice Ojwang used to call people who write in pamphlets, not in law review articles. I have not seen a critique of IEBC in a law review journal where you can agree. But there are so many pamphleteers, that's the word I think Justice Ojwang used to use, or newspapers, my lord. People who write legal opinions. And one of the biggest critique of Raila versus IEBC was that the court relied on Nigerian authorities. So what? Nigeria is a superpower in all spheres of manifestation. It has 4 or 5 times our GDP. It has 4 or 5 times our population. I mean, Nigeria, my lord, is, even in terms of jurisprudence, we may have an unflattering experience about Nigeria, but you can't ignore Nigeria, both in its economic setting or even its political setting. But my lord, it's my humble submission that Raila Odinga vs. IEBC 2013 is good law, my lord. You settled the law on all those issues. You did it in a very eloquent, beautiful manner. It's a case, my lord, that has been quoted many places, many jurisdictions. And my lord, it's a case you have subsequently validated it in Nadif Jama case, in Zakaria Obado's case, in Bitamunya's case, in Kidora's case. So, my lord, it's actually what is called a solid rock precedent of this court. So, my lord, in my humble submission, I see no reason why any of the issues you have raised in that judgment should be disturbed even for a moment. My lord, let me take you now to the issue of precedent. Why do I take you to the issue of precedent? Because there's a trilogy of cases by Peter Munya case, my lord, Nadif Jama case, and Zakaria Obado's case, where you have addressed these issues over and over again. The issue of the burden of proof, the issue of when does the court invalidate an electoral dispute, all those issues. And my lord, I want to persuade this court that since you have established the law on firm and solid ground, you don't need to deviate from that. You need to fortify it. And my lord, I don't want to go to the history of why this court, the Supreme Court, was established when Kenyans were agitating for constitutional reforms. But my lord, you will all appreciate, my lord, that because of the sorry state of the law in the 80s and 90s, where one court will decide the law this way, and the same court in the afternoon will decide the same issues differently, there was an agitation to have a Supreme Court which could create jurisprudential coherence, some solidity, some law and order. And my lord, to the credit of this court, on most of those issues, there is that solidity you have created in the last 5 years. There is that soundiness you have created. But my lord, I think I just forgot to highlight one thing in relation to the Raila case. Because my lord, the court was conscious. If you look at paragraph 177 of that judgment, the court was conscious of the historic moment it faced at that point in time. And my lord, if you look at that, the court, to its credit, delineated 6 issues why that judgment was of epochal significance. It was a very significant judgment. And the first one, my Lord, you said that although the law and the facts are not that heavy, you said that it is the first landmark case bearing on the early steps to consolidate the progressive and the unique constitution. The second issue you captured, my Lord, you said is that it shows the importance of the court in resolving disputes, even of the magnitude of a presidential election. And you go on. Third one, my Lord, you said is transition of the executive. There is the fourth one, my Lord, the cardinal role of the implementation. The fifth, my Lord, is you are alive to your duty as a Supreme Court to base the law on firm and solid foundation. That's what you said, my Lord, in paragraph 5 and 6. And my Lord, to the credit of the court, my Lord, I can attest that that judgment and subsequent decisions of the court have validated that. My Lord, I don't have to say this obvious, but stare decisis is not only the foundation of the common law tradition, but my Lord, it shows when a court follows stare decisis, it shows that the rule of law is well and alive in that country. When a court decides similar or same cases in a coherent and in a manner that is all same, it shows, my Lord, that that court adheres to the rule of law. And my Lord, when a court decides one case or two cases of similar facts differently, then you know that that court, there's chaos. And when there's chaos in the court, my Lord, there will be anarchy in the country. And my Lord, that brings me to Article 163(7), which says all courts other than the Supreme Court are bound by the decision of the Supreme Court. And my Lord, the fact that I don't think, my Lord, there is any country, to my knowledge, which makes adherence to a precedent a constitutional principle. This is one of the rare cases where the constitution of a country says, no, all courts must adhere or must follow the decision of the Supreme Court. And that underscores the problem I just highlighted. There was so much chaos in the jurisprudence of this country. The High Court could decide how it wants, the Court of Appeal could decide how it wants, that the drafters, if we can use that term, the drafters of the Constitution say, no, we must have a constitutional principle that says that all judges must adhere. It shows the enormity of the problem this country faced. But my Lord, can this court, when it interprets a constitution, when you interpret a constitution and you tell the country that this is what this constitutional provision means, can you depart from that? And my Lord, my humble submission is that you can't, notwithstanding Article 163(7). Unless, my Lord, that the decision or the decision you have reached in that interpretation of the Constitution was so erroneous, so untenable, so unpersuasive, that you may be allowed to depart as an exception. But my Lord, because of the apex nature of this court, when you interpret the Constitution, you are telling Kenyans that this is what the law means. My Lord, if you change after 1 month and say that, no, this is what the Constitution means, people will not take this court seriously, and I'm glad you have not done that so far. My Lord, let me just briefly draw your kind attention to one or two authorities on this issue. And my Lord, the first one, my Lord, is a book written by two American law professors. It's Authority Number 6, Volume 2, supplementary list, my Lord. My Lord, if you look at from page 849, you will find a book written by Daniel Fapper and Susanna Sherry. The first one, my lord, is a professor at the University of California, Berkeley Law School, and the second one is a professor at Vanderbilt University. The book is called Judgment Calls, Principles and Politics in Constitutional Law. Judgment Calls, Principle and Politics in Constitutional Law. And my lord, the court talks about precedents, especially constitutional precedents, and it addresses the apex court. My lord, I will just draw your attention to page 851, the last paragraph. Page 851, the last paragraph. Where the court talks of how does a continuing court, a court that continues like this one, address precedent. And then, my lord, at 852, the paragraph, the third line, which starts with, in considering the importance of precedent, we must first consider relationship to the rule of law. I don't want to read, my lord, but there's one page, my lord, I would like to read, and that's page 857. My lord, this is what the learned author says at page 857. They say, adherence to precedent does not mean simply refusing to overrule past decisions, but taking them seriously as a starting point for analysis in future cases. This is partly a matter of reasoning by analogy from similarities between the facts of cases, but more importantly, a matter of giving credence to the reasoning in an earlier question. The willingness of judges to differ in its own way to their predecessors and their expectation of a similar difference from their successors transforms courts from an ever-changing collection of individual judges to an institution, one which is capable of building a continuing body of law rather than merely a succession of one-time rulings. This kind of decision-making, which is familiar to students of common law, is structured enough to provide stability and coherence, but flexibility enough to allow improvisation and growth, creating a false dichotomy between precedent labelings such as unchangeable bedrock and others increase. So, my lord, when a court is a continuing court, my lord, it's always important to solidify precedent. If you change, for example, case law from one election cycle to another, then, my lord, the court or the jurisprudence of the court will fall into disrepute. But, my lord, page 860 is more profound even what the learned authors express in page 860. And this one, my lord, refers to constitutional precedents. This is what the learned author says, my lord, at page 860. They say, at least in certain kind of cases, precedent gets added importance in constitutional area. One purpose of having a written constitution is to create a stable framework for government. As even most originalists have recognized, this goal will be undermined if the court failed to give special credence to bedrock precedent that have become the foundation for large areas of important doctrines. Some obvious examples involve the ruling of the New Deal, upholding the validity of the social security system, and other federal taxing and spending programs, and those recognizing federal jurisdictions of the economy. This omelette cannot be scrambled today, as even the most devoted believers in originals often acknowledge. Likewise, it is far too late in the day to invalidate independent judges. My lord, go to the second paragraph, which says, it is not simply that it will be imprudent to overrule those doctrines, though obviously it will, but in an important sense, it will run against the purpose of constitutionalism. Overruling these doctrines will create just the kind of uncertainty and instability that constitutions, even more than other laws, are designed to avoid. And my lord, precedent, and I can say without any fear that Raila versus IEPC is a bedrock precedent. It provides the foundation of all other cases you have decided, and you should not depart from it. Lastly, my lord, I will not read it, but look at the last paragraph in 861 and the next paragraph in 862. My lord, let me go now to the fourth issue. When can a court invalidate a presidential election? When can a court invalidate a presidential election? And my lord, as I said in my opening submission, in my humble submission, this court can only invalidate a presidential election if it finds fault with the voter. In other words, for you to invalidate the presidential election, cogent evidence must be shown. For example, that in the border town of Mandera, there were 20,000 foreigners who voted who are not entitled. Or in Busia, there were 30,000 Ugandans who came.
Very careful when you mention that county.
Yes, my lord, I understand. Or my lord, in the border town of Moyale, there were 40 Ethiopians who came, who voted but were not. It is only when you can be shown that voters or people who are not entitled to vote under Article 38(2) indeed voted. My lord, the centrality of the voter or the Kenyan who exercises his political will under Article 38(2) cannot be emphasized. But my lord, to show that that is really the point, and this court has actually even expressed those. I will show you, my lord, that even though the court was not that explicit, there's a lot of inferences where this court have made in the Peter Munya case, where you say that it is Article 38(2) and the exercise that starts and ends with that can invalidate a presidential election. But first, my lord, let me take you through the Canadian case of Ted to show you that even in developed democracies, the only or the major reason why courts invalidate elections is because voters who were not entitled to vote did indeed vote in that election. And my lord, that you will find, that is the second authority in the supplementary list. It's at page 1 to 33. My lord, I will not read, but let's start, my lord, with page 48 of that decision. My lord, page 48, I will just draw you the introductory paragraphs 1 and 2. Then, my lord, I will draw your attention to page 56. You will read at greater length when you retire. Page 56, my lord, paragraph 23. Then, my lord, if you look at page 57, paragraph 24, look at how the court defines irregularities that affects the result. And my lord, the court said, and this is the Supreme Court of Canada, it says, this case involves interpreting the phrase irregularities that affected the result of the election. The phrase is composed of two elements, irregularities and affected the result. As we shall explain, irregularities are serious administrative errors that are capable of undermining the electoral process. The types of mistake, it goes on, my lord. Then, my lord, look at paragraph 25. It talks about affected results. Then, my lord, at paragraph 27, look at paragraph 27. It shows what is the foundation of a democracy. It is the vote. But, my lord, to show the centrality of the voter in any election, my lord, kindly look at page 64. That's paragraph 44, paragraph 46. And, my lord, paragraph 50 and 51 now shows the point I've been emphasizing. Look at 50, my lord, paragraph 50. At page 67. And my lord, this captures the essence of the vote, the essence of the sovereign will as expressed in Article 38. Look at paragraph 50, my lord, page 67. It says, the current system of election administration in Canada is not designed to achieve perfection, but to come as close to the ideal of enfranchising all entitled votes as possible. That's what an election is all about. It's about voting. It's about who votes. It's about who casts his vote. It's not about the technicality whether some results were transmitted from point A to point no. Why? My lord, the foundation is vote. Have the voters voted? Have the right voters voted? And then it says, my Lord, since the system and the act are not designed for certainty alone, courts cannot demand perfect certainty. Rather, courts must be concerned with the integrity of the electoral system. This overreaching concern informs our interpretation of the phrase irregularities that affect results. And my Lord, just look at paragraph 51 of that judgment. My Lord, lastly, I will draw your kind attention to page 69, both paragraph 55 and paragraph 56. Then at page 70, paragraph 57. And my Lord, paragraph 57 is a gem. This is what the court says. The substantive approach is recommended by the fact that it focuses on the underlying right to vote, not merely on the procedure used to facilitate and protect the right. In our view, an approach that places a premium on substance is the approach to follow in determining whether there were irregularities that affected the result. On this approach, a judge should look at the whole of the evidence with a view to determining whether a person who was not entitled to vote voted, my Lord. And my Lord, that is the essence of an election. Did those who vote, were they entitled to vote? Lastly, my Lord, look at paragraph 58, paragraph 59, and paragraph 60, my Lord. My Lord, quickly, let me just take you through the local jurisprudence of this court. And my Lord, I will start with Opado, who was the governor of Migori. My Lord, in that case, the difference between the two was a mere 600 votes. And Professor Oyugi, who was challenging, had the simple task to show that despite all the issues he pleaded, Governor Opado had 600 votes that he was not entitled to, my Lord. My Lord, he could not prove that despite all the issues he says, some signatures were not signed, some polling stations opened late. The court told him, show us simply how we can deduct 600 votes so that we can call a by-election. And he couldn't show. My Lord, the same applies for Peter Munya. Peter Munya, Zakaria Opado, and Nadif. The difference between the winner and the runners-up was less than 1%. And in all those three cases, the court made one simple test. Numbers matter. Show us that the winner has certain numbers which he is not entitled to have. But my Lord, I think the most authoritative, the case you have addressed these issues most is the Peter Munya case. And I will just take you through that very quickly. My Lord, I will start at page 158. That case, my Lord, starts at page 158. But my Lord, to show the centrality of the voter under Article 38.2 is captured in paragraph 205A. You have acknowledged that, although you did not expound it, if you look at paragraph 250AA, this is what the court said, my Lord. It's at page 200 at the top. My Lord, this is what the court said. We will state as a principle of electoral law that an election is not to be annulled except on cogent and ascertained factual premise. This principle flows from the current democratic theme of the Constitution, which safeguards for citizens the freedom to make a political choice under Article 38.1, my Lord. My Lord, that's the foundation of a whole election. So when a choice has been made under Article 38.1 of the Constitution, for one to annul, you must find that there were certain mistakes that were done. My Lord, I will not read it, but I will kindly draw your attention to page 203, page 204 of that decision. And my Lord, all those three cases will show that the task the petitioner faces in nullifying an election is a one-off figures. Just show us how the figures you are complaining about can be annulled. My Lord, my last issue is the petition, my Lord, before this honorable court. My Lord, it's my humble submission that this petition is so my Lord, it's my humble submission that this petition, my Lord, pleads no course of action. No course of action. My Lord, even if you lower the standard of proof to be one below on a balance of probability, this petition will still be dismissed. Even if you lower, if you establish a new test that says that the test is one below a balance of probability, this election petition will still be dismissed. My Lord, even if the court will have dismissed that application and say that we expunge from the records all the pleadings filed by the first, second, and third respondents, and you allow the petitioner to prosecute this petition in our absence, it will still be dismissed. Yes. It will still be dismissed, my Lord. Because, my Lord, even without any defense, there is nothing they can prove in this, my Lord. It's allegation of rumors. It's allegation of political hyperbole. It says that the election was conducted so badly, and you don't give particulars. But my Lord, as my learned friend yesterday is rightly captured, and I said this, my Lord, when I was starting, this petition is a science fiction, my Lord. It's a science fiction which will only interest directors and actors in Hollywood. Because, my Lord, this petition is based on the theory that results that were being transmitted by the first and second respondents were intercepted by either aliens or extraterrestrial forces, changed it in favor of the third respondent. Don't explain why it was not changed on behalf of Dida or my friend Ekuru, but for the third respondent, manipulated at a frequency of 11%, and the third respondent won, my Lord, as a result of that. That is pure science fiction. It can't, it's so absurd that someone can put a chart there and say that the third respondent will win an election because a computer chip has been placed somewhere that manipulated the result that led to a result that the third respondent won the election. My Lord, when my learned friends from the IEBC said, leave alone about that, from the raw data on Form 34, A and B and C are there. Look at it and show us what difficulties you have. And my Lord, they had no answer to that. And my Lord, when they were supplied with those Form 34s, as required by the rules of this court, my learned friend, my Lord, Orengo said from the bar that they were photocopies, they were not original. The best evidence the petitioner has adduced, my Lord, is those evidence by his lawyers. That is the best evidence. It's not by the petitioner and his witness in the affidavits, no. The best evidence, my Lord, is the one adduced by Orengo from the bench. But that itself is not enough to prove his case because it was hearsay when he said, for example, that those Form 34s are not original, my Lord. Those are hearsays. That's not what a lawyer should say. So, my Lord, I have 20 more minutes. I will give to my learned friend. But, my Lord, I have shown that this petition is not a petition that is grounded in law. It's grounded on other grievances, my Lord. It's not law. It's not a course of action. The figures and the numbers, my Lord, are clear. And, my Lord, for you to invalidate that presidential election, you have to show the bottom line, that the 14 million Kenyans who elected everybody else, and there's no quarrel about all the MPs, the MCS, the senators, the women representative. Nobody is unhappy about that. You have to show that those 14 people should not have voted, and they should not have voted in the manner they have voted, my Lord. My Lord, it's not the result one should be annoyed with. Because in every contest there are winners and losers. No. You must have a bona fide, concrete course of action for you to be aggrieved. The result is a natural consequence of Article 34(2). My Lord, unless you have any questions, that's the end of my submissions. I am most grateful, my Lord Chief Justice.
Thank you very much, Mr. Abdul Nasir.
Thank you, my Lord.
Thank you. Mr. Rengo, you have something?
My lords, my ladies, I'm sorry.
If it's about the application that we were warned that will be made by my learned friend, we prefer he makes that after we have concluded our submissions, so that there's a natural flow in our submissions. It will be quite unfair that we now get an interruption about events elsewhere, and then I go back to our submissions. We should be entitled to equally have a nice flow of our submissions without any interruption.
Mr. Ngatia,
Yes,
you know, following our order yesterday,
yes,
there is a parallel process going on
yes.
with regard to the scrutiny of the documents we give. If we wait until you finish, that may delay that process. So let's hear what Mr. Rengo has to say, then we can continue. I don't think he will interrupt your flow of thought in the matter.
I hope you've then prepared.
Mr. Rengo? Yes, Mr. Mwite?
My Lord Chief Justice, we have seen the letter addressed to the registrar of this court, and copies of which we are handed over to your Lordship this morning.
Yes.
I have been in touch with my client, and we expect in the next 30 or so minutes to have our client's version of events in writing before your Lordships. And I think it is fair that your Lordships listen to my learned friend James Orengo when the response of the Commission is also before your Lordships, so that you can give directions if there is any need to when you have heard both parties.
Mr. Mwite, we don't know what Mr. Rengo wants to tell us. We will be able to decide whether or not we can interrupt the proceedings. Let Mr. Rengo say what he wants to say. We will be able to deal with that.
I shall go along with your Lordship's directions, safe to observe that it's perhaps not rocket science what he wants to do, because it's already in the letter. But I'll go along with what you have suggested.
Thank you. Mr. Rengo?
I'm grateful, my lords and my ladies. As you know, my lords and my ladies, there are two exercises going on. One at the IEBC headquarters, which is in relation to the ICT-related issues that were subject of the court's order, and one that is taking place at Milimani Court, which is basically to look at the documents, the forms more specifically. My Lord, I'm not making an application, but just giving an update, because it may have an impact towards the later part of the day when this matter will be dealt with. At the Milimani court, the exercise of examination of documents is going on, but the trouble is that some documentation is not being made available. But for those that are available, the exercise, I think, is going on smoothly. And we just wanted some directions that this matter should be expedited. Otherwise, we'll end up with a situation at 5 o'clock with the exercise not being completed. But the most serious one is what is going on at the IBC headquarters. I think people, representatives are there, but there is substantial non-compliance. And we have written a letter to the court, and my lords, without taking a lot of time, a perusal of that letter will show that there's substantial non-compliance. Again, we are raising this not in terms of making an application, a formal application, but just to update the court, and this will have an effect into what we are going to submit on at 5 o'clock when we're given that opportunity. That's all that we wish to say, your ladyships and my lords.
Yes, Mr. Mwite.
My Lord, on the first issue regarding the scrutiny of Forms 34As and Bs, I wish to support the sentiments of Honorable Rengo that perhaps this court needs to give instruction to directions to its registrar to increase the staff that are undertaking that exercise. Because from what I understand from my client, the number of staff is too low to be able to accomplish that exercise in good time. So we are also anxious that that exercise should be completed in good time before 5 p.m. And the way to do it is for the registrar of this court to increase staff to such numbers as will enable the exercise to be completed in good time. On the second one, the issue of access ICT. My lord, these servers are in Europe.
Sorry?
The servers are in Europe. We are not refusing to give access. Europe is a couple of hours behind us. We had to wait for them to start working. They have to set up the access window with safeguards. That exercise is going on, and I am instructed that that should be completed in the next 1 or 2 hours. So it's not us who are refusing to give access, except with regard to the soft copy that your order has directed we give to them of the logs. We have added a soft copy to the registrar, but my instructions are that our opponents did not accept the soft copy. So as far as the access is concerned, the soft copy, we have complied. The second component of actual access, in accordance with the orders of this court. In fact, my clients are going further because there are some things that are beyond the orders that we are given by the court. But even those that are beyond, bearing in mind the concerns about the integrity, we want to accommodate them by giving them access. And that is what is being worked on by our service providers in Europe, and that should be in place within the next 1 hour or so.
Could I?
You also want to add something, Mr. Ngatia, you want to add something on that?
Yes, my lord, because the application also affects the third respondent. My Lord, it should be remembered that access is not just to the petitioners, it is equally to the third respondent. My instructions are as follows, my Lord. As regards the team at Milimani Court, they are moving very well. They are about to complete Form 34B. And they anticipate by midday, they'll be towards concluding that exercise. As regards the other team, there is a request being made by the petitioners which is beyond the order that was issued. What that is, my lords, I would request an opportunity for my technical team to respond to this letter in writing, just like to respond to the request which has been made. My lords, if there is a request which is beyond, that is really overreaching, both parties should be bound by what was to be made available to them. So, my lords, I do not think is that this time there is any alarm. The registrar, as learned counsel Mr. Moite has said, is in full charge of the process. And we anticipate by early afternoon that results would start being made available. That is all.
So there is no obstacle to complying with the court order?
No, none.
None.
There is no obstacle with complying with the court order?
My written instructions and also through my telephone, there is no obstacle.
Yes.
And it's being done plainly in the presence of everybody. But there was a request for a facility beyond the order that was made, and that was turned down. If that is what is being called an obstacle, is to use the word obstacle wrongly. That was a request beyond the order, and that will be put in writing in the terms that I'll be able to present to the court.
Tell your clients to observe the court order.
No, we are just receiving. We have nothing to do. We are receiving.
Tell the clients to observe the court order.
Yeah, it is actually
my clients, not his client.
Yes.
And my lord, it's an issue of logistics. We want to comply with these court orders to the letter. And there is no difficulty about that. It's an issue only of logistics, not obstructing, not wanting to comply. And we are going to explain that from our technical team to show the challenges that are there. But the orders will be complied with. Yes.
Okay. Then
We
Mr.
don't want the impression created that we are obstructing or not wanting to comply with the court orders.
Yes. Then Mr. Rengo, why are you interrupting our proceedings? No. I'm saying what they are saying, the court order is being followed to the letter. Why are you here?
No, my lord, that is not true. In regard to what my learned friend, Mr. Paul Muita, said, he's saying there's no non-compliance because the people in Europe are still asleep. My lord, you remember these orders were made when they were well awake yesterday. So the excuse of saying that the people in Europe are still asleep, I think is not justifiable. By the time these orders were made yesterday, and Europe is about 2-3 hours behind us, they were fully awake. Now we are being told this morning that we have to wait until they wake up. And my lord, you would expect this matter to be concluded by 5 p.m. So what we are just urging is that there should be full compliance. We are not going beyond the orders of the court. We are very conscious of what those orders of the court were, and we are quite happy with the orders the court had made. So we need compliance in time so that when we come here at 5 o'clock, and remember, my lord, we are only going to be given 10 minutes. So we need also to prepare our responses so that we don't take a lot of time from the courts. So that's all that I wish to say.
Very well. We gave the order yesterday morning. It is for the parties and their agents to work out and comply with the order within the time specified by the court. At 5 o'clock, we want a report. Anybody who will not have complied with the court order will tell us why he has not complied, and we will determine whether or not failure to comply was reasonable. And we will deal with that. Thank you very much, Mr. Ngatia. Can you now proceed? I hope that has not interrupted your train of thought.
It has not. It has not, since Mheshimiwa was one of our candidates in the electoral contest as well.
Mr. Mwite and Mr. Orengo,
Yes, Mano.
please communicate with your clients.
Yes.
To what? To comply with the court order.
We have and will continue to do so.
If some of your clients' agents are in Europe or wherever, they must have been told yesterday, wake them up and get the order done, complied with.
My Lord, the clients are here in Nairobi. It is their service providers who are in Europe. The orders will be complied with, I assure this court, my Lord. But one to point, I think we need to be guided by the IT technical people here. And I think the Supreme Court has its own IT experts working with the registrar of the court, so that this report, we also factor in the technical aspects. Because I think when we are talking, we need to be guided by those experts.
Are they not there at the IBC headquarters?
Yes, they are there.
Yes, they will come and tell us. They will come and tell us, yeah.
That's all I'm asking.
Thank you.
Thank you.
Yes, we have given instructions for more staff.
Thank you.
To be increased at
Yes.
Milimani.
Yes.
So that the work is completed in time.
Thank you.
Thank you. Yes, Mr. Ngatia.
Thank you, my Lord. May it please you, my Lord. Your Ladyship, my Lords. Let me start by indicating that we have filed written submissions. I rely on those written submissions. I rely on the written submissions and all the affidavits that we have filed. My Lords, in making the submissions which I'll be making this morning, it's now afternoon, I'll be assisted by my two learned friends, the young lady Melissa Ngania, as well as Hilary Segei. My Lords, let me start at the beginning. A presidential election is an edict of the Constitution. It is set out in Article 136. It is Section 136 that provides that an election for president shall be held. And it will be held in the manner, namely, that all registered voters shall be accorded an opportunity to participate in that election. From Article 136, the next article that engages that election is Article 138. And it's important, my Lords, that I lay these articles bare, right at the word go, because that will define the parameters of this engagement. Article 138, sub-article 3, provides that in that presidential election, all persons registered as voters shall be entitled to vote. Voters will be entitled to vote. B, paragraph B, the poll will be by secret ballot. C, at the polling stations, IEBC will tally, verify, and declare the result. My lords, those are the precepts, the commands set by the Constitution. From those commands, one goes to sub-article 4, and this article, sub-article 4 provides that at least 1/2 of the votes and at least 25% votes cast in each of more than half of the counties will be the ones determinant of a victory. Sub-article 4, my lords, introduces a quantitative analysis. That quantitative analysis, my lords, it is not a term of art, it is actually one of the constitutional dictates. From those analyses, my lords, or from that analysis, one starts to see how the contest in a presidential election must be held. It must be held in the manner set out in Article 138, and then the qualification is set out in sub-article 4. My lords, from there one then engages Article 86 of the Constitution, and Article 86 of the Constitution provides how the election will be held. Number 1 is the use of a voting method. Number 2, the votes are counted, tallied by the presiding officer. Then the second tier, constituency level, and appropriate mechanisms are set in place. Having set out the constitutional principles, my lords, we then look at the petition before you. It is not an allegation before you that the persons entitled to vote did not vote. That is not an allegation. So going to the commands set out in Article 136, 3A, persons entitled to vote, it is not an allegation that any persons entitled to vote were denied the opportunity to vote. So as against A, my lords will tick complied with. B, the poll was by secret ballot. It is not an allegation before you that anywhere within this country there was any voting in a manner other than a secret ballot. So as regards that, my lords would be entitled to say complied with. Number 3, upon the close of the polling stations, it is common ground, a tally and a declaration was made. So as against C, my lords will be perfectly entitled to tick complied with. Having complied with the commands set in the Constitution, then one naturally goes to sub-article 4. Sub-article 4 required all the votes to be tallied, and then you get the candidate with more than 1/2 of the votes cast. From all the material before you, the third candidate is the candidate, or the third respondent is the candidate who had more than 1/2 of the votes cast. So as regards A of 4, one can answer emphatically and without any fear of contradiction that the evidence shows that the third candidate or the third respondent is the candidate who garnered more than 1/2 of the votes cast. And C, again, it must be common ground that the third respondent had 39 counties in Kenya, 39 counties in Kenya which gave him more than 25% of the votes in those counties. Hence, as requires how the election is to be held, my lords, the election complied with the Constitution, and as regards who was the winner, again we see, my lords, the evidence demonstrates it's the third respondent who was the winner. So the question, therefore, must come, on what circumstances can this election be invalidated? And the petition is quite right. The petitioner is seeking an invalidation of a process that was valid. It is valid, as I have indicated, because it complied with all the constitutional provisions. So the petitioner is now seeking to invalidate which was otherwise a valid election. My lords, I have set out those articles of the Constitution because it's very easy to fall into a trap and regard a contest at this level as if it is a contestation at the High Court on other elections apart from the presidential election. Other elections other than the presidential election, the contestation would be based on Elections Act and qualitative approaches to that election. My lords, I appreciate that the Elections Act has a place to play, but that place is subordinate to the Constitution. I will now deal sequentially, but bearing those principles in mind, to the issues that have been advanced in this litigation. I will start with the minor care judgment that was delivered by the High Court in June this year, barely 45 days before the date for the general election. Minor care is a case that started at the High Court, escalated to the Court of Appeal. At the Court of Appeal, NASA, a political coalition, sought to be enjoined and was enjoined in that appeal. As a matter of fact, I do recall Jubilee did not participate, but I do recall NASA was represented by, amongst others, my good friend, Senator Orengo. And a 5-judge bench of the Court of Appeal held, amongst other things, that the polling unit is the lowest unit where the poll must be held and a declaration made. That's the first principle of law that is set out in the minor care case. The polling station. Polling station is where the first declaration of a presidential contest is to be held. The next principle set out is that that document at the polling station is the primary document, and the word used is primary document. Why it is primary, my lord, is so that we can steer away from this contestation about mirror images of that document. Since it is the primary document, if there's any contest about a mirror image, then one must revert to the primary document because it is available. My lords, that case is the one that was, so to speak, the reference point during the last general election. A reference point because it determined for the first time that the votes tallied and declared at those early levels or early tiers in the contest are primary and final. Because they are final, they cannot be altered at the National Tallying Center, and those votes will be taken in their original form as declared at the areas of the electoral contest. My lords, many other cases were litigated. In total, there were about 27 cases, including a case that was adjudicated barely a week before the general election, requiring declaration of results within 7 hours from the conclusion of the contest. There were many cases. The next area I go to, my lord, is the polling date. On the polling date, my lords, it must now be obvious, as I indicated, that all the constitutional requirements were complied with. There is no allegation that elections were not held countrywide. There is no allegation that any Kenyan voter was denied the right to vote. There is no allegation that any region of this country was disallowed to vote. To the converse, my lord, we are in unison, in agreement, that polling was held throughout the Republic and in a very peaceful manner. Now, my lords, and this now I start to engage the petitioners. What we carried out in the polling stations is an electoral contest. And a contest of politics has its own uniqueness. It is not a contest in science. It's a contest in seeking voters from the electorate. So consequently, my lords, the Elections Act anticipates that there will be questions about the integrity of the process, and the Elections Act provides for observers to be accredited. Observers to be accredited so that they can ensure or be able to be critically analyze the integrity of the process. Many observers were accredited. My lords, in the affidavit of Davis Shield, we have produced many observers' reports. These reports, my lords, have statutory underpinning. They are required by Section 42 of the Elections Act, and the report must be provided or submitted to IEBC pursuant to Regulation 94, Subregulation 6. So these reports are not without a basis. They have a basis in law, and they are a requirement because it is the first assessment of the electoral contest. And as I keep on referring to this, my lord, it is an electoral contest. My lords, in this affidavit by Davis Shield, we have attached various reports. At handwritten page 4 is the first report by ELOG, Elections Observation Group. On the first page, they say, and there is no dispute, they had 8,300 observers in all the 47 counties in Kenya. They had 8,300 observers. I go to handwritten page 6. On the election day process, I read, ELOG observers were properly permitted to observe in 98.4 of the polling stations. I'm at handwritten page 6, my lord. Air-log observers were properly permitted to observe in 98.4 of the polling stations. No, handwritten page 6. The annexures. And then voting, we see that 7.6% of the stations, the KIMS kit failed. I'll go very quickly to page 7, where I'm looking for closing and counting. I read the first bullet. An ODM, Wiper, ANC, or Ford Kenya Party agent representing the NASA coalition were present, and this is important, my lords, were present in 84% of all the polling stations. In stations where they were present, the NASA agent signed the declaration of results for the presidential elections in 93.8% of those polling stations. In 93.8% of the polling stations, NASA agents signed the declaration for the presidential elections. My lords, this next bullet, for the closing and counting process, a Jubilee Party agent was present in 92.3% of all the polling stations. In stations where they were present, the Jubilee agents signed the declaration of results for the presidential elections in 95.8% of those polling stations. So, my lords, without even going any further, you see that the two candidates had agents throughout the country, and those agents signed the presidential declaration forms. My lords, we go to the next page. E-log, with so many observers, had a projection on how those candidates had fared. I'm on page 8. Their projection before the results were announced, before results are announced, was that Uhuru Kenyatta will get 54% of the votes. When the results were declared, he had 54.3%. One can see the near accuracy of their projection. Odinga Raila, they say they projected 44.9%. He got 44.7%. Again, very near to the eventual outcome. Why do I say this, my lords? It's because in an electoral contest, the participants to that contest are able to very well determine, number one, issues of integrity, and number two, who is likely to be the winner. My lords, in this observer's report that was submitted in compliance with our domestic law, there is one recurring theme. The process was free, fair, and credible. Free, fair, and credible. My lords, I go to the next observer's report by the African Union. It is at handwritten page 10, and it is dated 14th August 2017. At page 13 of that report, they make this observation. Based on his observations as reflected in his preliminary statement and the observations in this supplement, the AU is therefore of the view the presidential election results publicly announced by IEBC are a true reflection of the will of the people of Kenya. A true reflection of the will of the people of Kenya. I move quickly, I'll move quickly to another report. This is a report by the Commonwealth, and this will be found at page 26 of the annexures. A report by the Commonwealth, my lords. And I am looking at page 31, the paragraph starting with, in this regard. In this regard, we commend the reassurance of the chairperson of IEBC that results will not be declared until that form. And then at the bottom, our overall conclusion, this is the point I'm looking for, our overall conclusion is that the opening, voting, closing, and counting process at the polling stations on 8th August were credible, transparent, and inclusive. They use different words: credible, transparent, and inclusive. Proceeds, we commend and congratulate Kenyan voters, the staff of IEBC, political party agents, candidates agents, the media, and all the security personnel for their commitment to the democratic process. They were efficient in the conduct of their respective roles, which contributed to the conduct of a peaceful poll on 8th August 2017. So apart from credible, transparent, and inclusive, they also give it another tick. It was peaceful. And that, again, my lords, is a point I would wish to buttress in a second. Throughout the day of 8th August, the elections were held in the most peaceful manner. There were no riots, there was no commotion anywhere, and that is not an allegation before you. We are in agreement that we are peaceful voters, and we participated in our civic duties in accordance with that expectation. My lords, based on those observers' reports, I would request my lords to hold and find that the process was carried out, integrity is demonstrated, and in this electoral contest, my lords, what one is looking for is a wholesome approach to that process, not a utilitarian principle approach, which means self against all the others. I will therefore urge and request my lords to hold that this process had all the hallmarks of a process that was credible. I go to what has been thrown at us. Number one, results started streaming at 5:07. And that is supposed to be a complaint instead of a compliment. A moment ago, my lords, I indicated to you, when you have time in the affidavit of Winnie Nguchu, you see we have analyzed all those cases. Even a case requiring results to be declared within 7 hours. So they start streaming at 5:07, and that becomes a complaint. Let me deal with that complaint because it's important I deal with it. It is true, my lords, that the first result that streamed was at 5:07 from a polling station where the first petitioner had 6 votes and the third respondent had 4 votes. So the votes cast in that polling station were 10. 10 only. And there's no argument that there were only 10. But the argument is it was very quick for those results to stream in. My lords, how long does it require to count 10 ballot papers in the presence of agents? You hold 1, 2, to count 10, my lords. We do not want to waste your time. Would be something towards 2 minutes, if not less. So for results to stream at 507, it's a polling station. Narok is from a prison, Narok main prison. The next stream was at 508. Where the first petitioner had 9 votes, the third responded 3 votes. So total votes 12. And I'll only give 3 more. The third was 509. First petitioner had 5. Third respondent had 7. And all the timesheets are before you, my lords. And then we go to 512. Petitioner had 3, third respondent had 43. And finally, 514, where petitioner had 42, third respondent had 3. My lords will see that those were polling stations, and their polling stations, all the timesheets are before you, and they will be found in the affidavit of Davis Shishil, who was the chief presidential agent. And those are documents, my lords, that all chief agents were given access to, and every party agent had access and was given copies of all these. From that analysis, I request, my lords, to make the following deductions. First, that polling stations did not necessarily have 700 voters as submitted by one of my learned friends. And number 2, that formula that was displayed before you for a long time with a mathematical basis which is unknown to any other person other than the author of it, has no application. Because from these results, one can be able to see that all these candidates are getting votes from polling stations in a manner peculiar to that polling station. There was no mathematical predetermined way of voting in the contest, and there can't be. As a matter of fact, even going by the declared results, one will see not a difference of 11%, which persisted even yesterday. I would have expected really by a process of deduction that one will see, you cannot say 53 points, is it? Yeah, 53 against 44 cannot be 11%. My lords, I will be turning to those arithmetic in a little while. But that mathematical formula has absolutely no application whatsoever. My lords, the streaming in of the results was as a consequence to the process that had already been started of having a very free and fair election, and an election which was conducted peacefully, and counting and tallying of votes started taking place immediately after 5 p.m. My lords, I dealt with the observers' reports. I went to the streaming. It will be a good point for me to indicate that we have a video of one of the persons who participated as an observer, and it will be important, my lords, for you to hear what is said about our elections. This is Mr. Kelly, who was a candidate in 2004 as a Democratic Party candidate in the United States of America. Having been a presidential candidate and having participated as an observer in our elections, his views, I would submit, would have a bearing a bearing on what took place. Hey, time.
So much for joining us on the preview. I want to start out by asking you about Odinga's comments that the results of the election are fake and factitious, about these allegations that certain voting machines were defunct. How do you respond to that? What have you observed?
Well, we observed a election process, more than 400 observers from 9 different international missions all agreed that the basic process of carrying out the election was quite positive. There were little aberrations here and there. But at this point in time, I want to be mindful, the election is still going on, they're still counting, the process is still underway. But we believe that the Elections Commission in Kenya has put together a process that will allow each and every vote's integrity to be proven and to be protected. We think that the open process we witnessed, where every party agent was present, where they all agreed on what a disqualified ballot was, what a qualified ballot was. They were present when the ballots were open, present when they were closed. They even were asked, do you agree with the final tally? And after there was all agreement, the tally was sent in on what is called this 34A document. So there is a way to go back. If anything was changed, if anything was electronically fiddled with, there is a way to go back and absolutely ascertain what happened in the polling station. So by paper ballots, there is a protection of each and every Kenyan's vote. And I think it is important to let the process work through so that the Election Commission has a chance to show Kenyans the way in which they have held to the rules and, in fact, implemented an election that is accountable.
So given what you observed and what you've just said, what do you make then of Mr. Odinga's comments?
Well, I'm not going to characterize any candidate's comments at this point in time. You know, he is a candidate for president of Kenya. He has a right to question certain things. But I also think he obviously has a responsibility to Kenya, to the democratic process, to the rule of law, to make certain that he is providing the evidence and going through the legitimate judicial process that is there for examining any kind of concerns that anybody has. Every observer group is asking for all of the leaders to be responsible, to allow the process to work out, and to put to test the system that has been put in place where transparently and accountably to everybody, in the full light of day, people will be able to see what happened on a particular ballot in a particular balloting location and examine whether or not the process was properly followed.
We are hearing of some protests yesterday. 2 people have been killed so far. Are you concerned about this violence?
Well, all violence is unacceptable. And of course, anybody is concerned, anybody in their right mind is concerned about the potential of violence getting in the way of the legitimacy of this process. This is not an electronic vote, ultimately. It's a paper ballot vote. And so it is determinable as to what happened. And I think it is important for all of the candidates to allow the process to be transparently put to the test. And then if they have a concern, go through the rule of law, go to the court process, and let the evidence be there for everybody to see. I think there is great legitimacy in the basic process. The question now that has to be tested is, did everybody follow it? And has it, in fact, has somebody attempted to alter it at any stage. But the important thing for people to know, for every Kenyan to know, this is their election. It's their individual votes that they waited in line for hours to cast. And we believe, the Carter Center believes, and the other observers believe, that we can determine whether or not those votes were properly cast, properly counted, properly transmitted, and whether or not the integrity of this election has been protected. And that is what is critical to every Kenyan and everybody who cares about democracy.
My Lords, from that interview, my Lords would have observed that Mr. Kerry was in the company of over 400 international observers. It was their observation that the vote, the integrity of the vote was protected, and that is a constitutional requirement, protect the integrity of the vote. My Lords, agents were present. Agents agreed to the tally at the polling stations. The percentage of the agents has been tabulated or indicated in the e-log report is over 90%. And very important, my Lords, if there is any problem with transmission of the Form 34A, one simply goes back to the manual 34A, because as our Court of Appeal said, it is the primary document. So we shouldn't have a contest on transmission. We should have a contest, if any, on the numbers in 34A, because those numbers can only speak one voice. You cannot therefore found a presidential petition, engage the apex court on questions of transmission, because transmission at the end of it all is a conveyance. It is not an originator. Responsibility is underscored, a responsibility on all the political players across the board, because what they are doing is litigating the rights of Kenyans, not their individual rights. My Lords, given all that, would it be possible or would it be viable to challenge this outcome on the basis of infractions at municipal law level? We go to the infractions that have been advanced before you. My Lords, one of my learned colleagues for the petitioners took a lot of your time going through the affidavit of Dr. Oduo, in which a multitude, a whole litany of grievances are set out. Those grievances can be described or categorized into two groups. Group number one, contentions that for his candidate or for the petitioner, at one point he had 10 votes, but what was posted is 8, so a deduction of 2 votes. And for the third respondent who had 10 votes, he is increased 1 vote, and then it becomes 11 votes instead of 10. And he took that, a whole region, and very, very many paragraphs, The next category is the non-numerical category. The category where forms, he says, are not clear, or they are not signed by agents, or the forms are so faint you can't make anything about them. My lords, those are the complaints which are the basis upon which a very exaggerated with respect a submission was made that the elections were shambolic, and being shambolic, they should be declared invalid so that a re-election can take place. My Lord Chief Justice, I do recall, asked the council, what is the effect, what is the numerical effect of all those complaints? And there was loud silence. Let me now take the hint from that question and deal with the numerical effect of all those so-called irregularities. May I request the court clerk, if you could, is an annexure to Winning Guchu's affidavit, subheading alleged numerical discrepancies. Maybe other judges as well, if you have copies. Very well. It would appear the clerk had only one. My lords, at page 1, what we did is to take all those allegations and anticipate the question, because that question must be raised. What is the effect of those numerical discrepancies? So, my Lord Chief Justice, starting with the first one so that I can indicate, we have dealt with the paragraph. Number 1, we have dealt with the paragraph where the allegation is. The allegation is, it is not indicated petitioner had 66 votes, yet in Form 34B, it's indicated 56. My lords will recall the 66 and the 56. Then our response, false. Petitioner had 56 votes in Form 34A, same as 34B. Total tally is indicated. So, my lords, we have gone to the extent of saying where it is a false allegation. The allegation that the petitioner had 66, and then that was reduced to 54, is a false statement of fact. And then we have dealt with it all the way to the end. And at the end, because at the end of it all, we ought to be looking at what numerical difference. My Lord, if you could turn to the last page, the petitioner is the third one, starting from the right, where you see 822 votes. From all the discrepancies, each one of them, all that the petitioner would receive is an additional 822 votes. From all the discrepancies, 822 votes. Analyzed allegation per allegation. Then the third respondent is the candidate with 974. Again, from all the discrepancies, the third respondent's vote tally would reduce by 974 votes. Is my Lord with me? Hence, my lords, from all those so-called discrepancies, the end result is, and I use this word deliberately, insignificant. totally insignificant. My lords, in the fullness of time, you will see how many are false allegations and how many are true allegations. Where it is a true allegation, my lord, we have tabulated it for the petitioner for the benefit of this court. We have done that which the petitioner had a duty to do, which is say these are the irregularities, but demonstrate numerically what do they read to. My lord, we now go to the non-numerical discrepancies. We go to the non-numerical discrepancies. And against the non-numerical discrepancies, that goes hand in hand with a document, the bigger no, the bigger one, yeah. It goes hand in hand with this other document, analysis of alleged non-numerical discrepancies, because we had to give, to place before you the documents themselves. And let us start with the first one, my lord, the one on regarding Form 34A is uploaded on number 2, first page, my lord. No, the big, yes, because that's the summary. Yes, we go to number 2. In paragraph 139, the contention is Form 34A is uploaded in the Commission's portal are not clear or legible. Our response is false and true. The form attached are clear and legible. This is in Mombasa, Jomvu, Miritini, World Bank. Where do we get that document? We go to this bundle. Yes? Yeah, oh, good. My Lord Chief Justice has it. And then the first page is about paragraph 139. Write the first page, paragraph 139. And then, my Lord, we'll see the Form 34A is attached to it. It is quite clear, it is quite legible, and more important, is signed by all the candidates' agents. My Lord has seen that? And then, if my Lord could bear with me, turn to the second one, still at paragraph 139, page 10, handwritten page 10, just to demonstrate the falsity of these claims. It is contended it's not clear, but my Lord, at page 10, handwritten page 10, you see the document there is quite clear, as well as the next one is quite clear, yet the affidavit evidence before you is that those documents are not clear. Why have we gone to this extent, my lords? We have gone to this extent to demonstrate before you that all these allegations are untrue. They want to portray a picture of shambolic elections, whereas, to the contrary, the elections were fairly credible. And despite having presented this evidence before you, it was quite shocking for my legal team to sit in court and listen to these accusations one after the other about 66 votes being reduced to 54, whereas we have presented all the evidence before the court and served our learned friends so that they could, so to speak, reflect, have a self-referential moment and see whether they want to advance that theory anymore. Self-referential is a movement that costs nothing. It only cost one his conscience and his moment of silence. My lords, why did I use the term insignificant? I used the term insignificant because of the results that were declared. The results that were declared were that the third respondent had 8.2 million votes out of the 15-point-something million votes, and the petitioner had 6.8. The difference, quantitative difference, was 1.4 million votes, approximately. I say approximately because there will be a few thousands and a few hundreds. But let me deal with rounded figures because it will be easier. A difference of 1.4 million is significant. It is a difference that shows the will of the Kenyan electorate. And when one compares with the numerical differences which have been brought before you of 800 votes, then those numerical differences can only be said to be quite insignificant. That is not to say that we for one moment countenance even a single vote being taken from the first petitioner to the ballot of any other person. We do not. But we appreciate that is our fellow brothers and sisters who are doing this tallying process in very difficult circumstances. Circumstances which have received judicial recognition in our courts. Kenyans want the outcome immediately. The clerks have been working the entire night and the entire day. So errors of addition may arise. But it is an electoral contest. It's not surgery in theater. While liars, we have demonstrated that our worthy opponent votes tally 800 were deducted by error. What must be said, my lords, and I want to say it as humbly and as firmly as I can, that was not at the instance of the third respondent. He had nothing to gain from an extra 800 votes. He would not even countenance such an error, but we accept. As a matter of fact, if a similar exercise was carried out for the third respondent, and we have carried it out, we lost about 2,000 votes. Some posted to the candidate just next to us. A place where my client had 100 votes is posted to Wainaina. and Wainaina has 0 vote, is posted to my client. And those things do happen. At the end of it all, my lords, one is looking at the greater good of the process instead of what is scientifically a scientific impossibility. My lords, I move to the next point, which is a complaint on rejected votes. I would wish to associate myself with the submissions made by Ahmed Nasir. Those rejected votes have been analyzed in a similar exercise as we have analyzed, and the analysis will be in the affidavit of Mr. Davis Shishil. The rejected votes at the last presidential election was approximately 81,000. It is our submissions that rejected votes cannot be taken into account in the final tally. It was a point that we argued in 2013. Nothing has changed since then to warrant a departure from the judgment that this honorable court made. Apart from the principle of stare decisis, there is a greater principle that in these electoral contests, which is nothing more than a political contest being now brought to court, that there should be a fair degree of predictability, a fair degree of uniformity in the judgments from the court, so that our political players do not all the time seek a departure from what has been decided previously. My lords, the next point I would wish to deal with is about polling stations without adequate coverage. The coverage was either 3G or 4G. My lords, prior to the polling date, my lords, it is common ground that political parties were informed, and Kenyans too were informed, about 11,000 polling stations which did not have adequate 3G or 4G network. And they were informed that the results from those polling stations will not be streamed as instantaneously, or the images from those areas will not be streamed as instantaneously as the polling stations where there was adequate coverage. My lords, we must accept one thing, that these telecommunication players do go where there is good business for them. So in places where there isn't a lot of our brothers and sisters, they may not find it very lucrative to invest a lot of infrastructure. So there are indeed places in Kenya without 3G or 4G network. In those areas, my lords, it's not that the voters were disenfranchised. On the contrary, voting took place. The votes cast in those places are captured in the affidavit of Davis Shishil, and in total, 3.5 million voters were in those areas, and their votes have as much of value and weight as the votes in other regions. So, my lords, it cannot be, and it's not a legitimate argument to say that this election should be invalidated because of anything about the 11,000 polling stations. On the contrary, the voting on those areas took place and the votes were taken into account as the votes from all other regions. All of them, without one vote being lost. And that is why, if I could elaborate a little, my Lord Chief Justice, we are in agreement that the polling stations in Kenya are 40,883. And even in the video by the late gentleman from IEBC, he refers to 40,800. We are in agreement. And the figure of 40,883 includes the 11,000. So it is not that this is a different segment from other polling stations. They are the same. And that is why this repeated complaint becomes impossible to understand. Because since all these are polling stations with Form 34A, if there's a legitimate grievance, why not go to the primary document, look at the raw data in the original form, not even in a transmitted form, but original form, and go through all these 34As, do a national tally, and come up with a result. My lords, I go to the next point, which is ungazetted polling stations. The less I say about this, the better I believe. There was only one polling station that came into being pursuant to a judgment by the High Court, and the votes from voting did take place, and the votes were included. And again, since it's a polling station, the votes do not in any way affect the difference, the quantitative difference between the two candidates. What I mean, my lord, is this is a polling station. The polling took place due to a High Court judgment. The decree is before you. The numbers that voted in that polling station are well indicated. The voters in that area had a constitutional right set by Article 38 to participate in the election of their candidates. And that cannot be a complaint adequate on its own to invalidate a national election. My lords, I have dealt with everything at a municipal law level, because one is dealing with transmission, one is dealing with tallying, complaints about 3G network and everything. My lords, all those do not come to the level of invalidating an election conducted in accordance with the Constitution, in our humble submission. I then move to the accusations against the third respondent. The first accusation against the third respondent is that he went to Makueni, threatened and intimidated chiefs so that they could all parade Kenyans in that area to vote for him. That allegation, my lords, has been dealt with incisively and decisively in an affidavit by Dr. Kibicho, who is the Principal Secretary, Ministry of Interior, in paragraphs 22 up to 25 of his affidavit. It is noteworthy, my lords, because this is an accusation against the third respondent, that Mr. Kibicho deposed, and it's not controverted, that he, Mr. Kibicho, received intelligence reports that certain chiefs were campaigning for candidates in that area. The names of those chiefs are deposed too in the affidavit. And they were campaigning for a political party, which is NASA. And he passed that communication or that intelligence to his appointing authority. And when the third respondent was in that area, he actually told all public officers in very general terms that none should campaign for anybody, and not even himself. And when politicians take to the microphone and say, look, people less engaged will be here, this country is larger than all of us, let's not do politics, that is not a threat. It is what is expected of people in public office. The results in that area, my lord, tell the truth. One could look at the antithesis of the hypothesis that was put forward. First, petitioner garnered 301,000 votes from Makueni. 301,000 votes. Despite the so-called intimidation, my client received a paltry 27,000 votes. A small decimal of what the first petitioner received. So where is this intimidation? It is disproved by the results at the poll. It is disproved by the fact that no chief was suspended from duty. It is disproved by the fact that no chief has ever been terminated from employment. It's therefore unfair, my lords, quite unfair, for an accusation of that magnitude to be made, directed at another political player, that you intimidated persons or intimidated public officers, whereas the opposite is there. The opposite is the true position. Still with the affidavit of the Principal Secretary, the next accusation is that the third respondent went to Kisii and Nyamira talked to the IDPs in those regions and bribed them to vote for him. Those allegations, my lords, have been denied by Mr. Kibicho in his affidavit, starting from paragraph 6 all the way to paragraph 19 in which he deposed, my lords, and this cannot be denied, that this difficulty of IDPs started after the post-election violence of 2008. Successive governments have tried to resettle the victims. The current government in office, in its own budget, provided funds for the persons who had not been resettled. That budgetary provision, my lords, and this is quite important, received approval from the National Assembly. These are not funds taken away from somebody's pocket. It's the National Assembly that approved that budget. And as a continuous process, IDPs are resettled throughout the country. And the resettlement of IDPs in Kenya is within a body that is deponed to in the affidavit, and which is known as the National Consultative Coordination Committee. It is that body that disburses funds to the victims. National Consultative Coordination Committee. That is the body that gets funds. The funds are approved by National Assembly, and they are disbursed directly to the IDPs. My lords, there is no evidence before you that any of the beneficiaries, be it in Kisii, Nyamira, or any other part of this country, because they are IDPs also, in the strongholds of the first petitioner, and they were also resettled, there is no evidence that any one of those beneficiaries was influenced by what he or she received as a resettlement from National Consultative Coordination Committee. Not a single iota of evidence. My lords, the next accusation, or before I deal with that, I leave that, there is indeed a direct authority that for any aspect to do with bribery or influence is got to be established that the inducement acted on the mind of the voter. Inducement acted on the mind of the voter and made the voter alter his decision. There can be an inducement, so to speak, in generic terms or in general. It's got to be an inducement that is specific and induces the voter to alter his mind. We shall make this judgment available to this honorable court before we rise. No, I understand we have already submitted. Sorry? This case is a high, let me get it. It's Andrew Elam against Mohammed Rahman from the High Court of Justice, Queen's Bench Division. Mohammed Rahman. R-R-A-H-M-A-N. Inducement. Inducement must act on the mind of the voter and must be operative at the material time. Next allegation against the third respondent relates to Cabinet Secretary Mucheru, who is in charge of ICT in government. I start off by making this submission that allegation is not in the petition. It only came to our notice yesterday in an affidavit that was served yesterday and which we begged time to respond to as the petitioner was presenting their case. What is this? My lords, Mr. C.S. Mucheru was never served with that affidavit, and within the limited period that we had, we were able to prepare, file, and serve an affidavit by Mr. Shishil, court-stamped 28 August 2017. It is not alleged, my lords, that Mr. Mucheru was campaigning for any party. What is alleged is that he was interviewed and he said he is entitled. Is that correct? Yes, he said he is entitled to campaign. So the allegation is based on an answer to a question. And surely an offense cannot be made or be, the answer cannot be the charge sheet of an accusation of such magnitude. Mr. Mucheru indicated his view about political neutrality, and citing Leadership and Integrity Act, he indicated that as a CS, he is entitled to participate in the affairs of government, including making such campaigns or advancing government policy as necessary. So, my lords, in my submission, that complaint falls flat on its feet because it is ill-founded. The next one is about CS Eugene Wamalwa and Mwangi Kionjori. I'll deal with them all at the same time, and Kazungu and Barara. All those allegations came yesterday in the affidavit that was filed, and those named persons were given no opportunity to respond to any evidentiary material that was presented. And I say this once again, those are not accusations or allegations that are in the petition. Those four persons, their names are nowhere in the petition. The petition? In the petition, my lords, after dealing with all the municipal law issues, the only reference to the third respondent, I'll get it in a moment, 31. The only reference to the third respondent is in paragraph 31. And the one that would be more pertinent to this would be 32, which reads, no, petition, yes. Petition, with impunity, I read, with impunity, the third respondent contravened the rule of law and the principles of conduct of a free and fair election through the use of intimidation, coercion of public officers, and improper influence of voters. No reference to any person. This is very generic, imprecise, without any particulars, and at most refers to public officers. The cabinet secretaries cannot be called public officers. They are state officers. My lords, one cannot make such a generalized allegation at the tail end of the petition, now, so to speak, drop in names of persons and give them no opportunity to give a response to those accusations. I would therefore request, my lords, to hold and find that all those allegations against the cabinet secretaries are without any foundation and to dismiss them. There is such a fundamental distinction between the public officers and their role and state officers. I have dealt, my lords, I hope, with quite a number of all the allegations against the third respondent, but I will deal with a few more because of the prejudicial effect they have or they may have on the mind of the court. Substantial time, my lords, was expended on transmission of votes. So I take that as another subheading, transmission of votes. It is common ground, my lords, that early this year, our National Assembly amended the Elections Act and infused it with technology as one of the methods that elections should be held. But let's understand where technology fits in the electoral process of 2017. Technology was there at voter registration. Voter registration was biometric. So there was full involvement of technology at voter registration. Polling date, voter identification by use of the BVI kit. Where it failed, and it failed in certain circumstances, the complementary method was used. After that, the ballot paper was manually given to the voter. BVR is BVR kit. The voter manually inscribed a symbol on the ballot. And all the processes after that were manual, including the counting and including the filling in Form 34A. All that process, which is the most integral process in the elections, was manual. And it concludes with Form 34A. Now that Form 34A, and we now see the rationale of it, you want elections or the results to be declared fairly quickly, is to be transmitted electronically to the constituency and to the National Tallying Center. But that transmission, my lord, is nothing more than a conveyance or a conveying mode of a document. As I indicated earlier, it does not validate, neither does it take away or add to Form 34A. because of its very insignificant weight, insignificant, my lord, because as we have seen, agents at the polling station signed the same forms. So each and every candidate will be able to know at the end of the day the number of votes the candidate obtained at every polling station. There's no magic in the transmission of Form 34A. My lords, in our submission, the whole purpose of this electronic transmission is a fast way of conveying the results to the constituency and to the National Tallying Center. Once that purpose is defined and delineated in those terms, any failure, not that there was any failure, but even if there was any failure, it cannot invalidate the results. Not the results at the polling station, not the result at the constituency, not the result ultimately declared at the National Tallying Center. It will be stretching logic to an illogical conclusion to say because transmission failed at this point, then those results are declared, or all the results are declared invalid. I would therefore urge you, my lords, to hold that although there was no failure in transmission, even such failure in future cannot be the basis to invalidate an election which was otherwise constitutionally compliant with all the articles or all the operating articles of the Constitution. My lords, before you are two positions, or what I will refer to as two realities. Reality number one is presented by the petitioners, and the reality, to put it very modestly, is that you allow another electoral contest to take place within the next 60 days. That reality, my lords, would mean that this nation, for the next 2 months, will be engaged in very, very contested political climate where all manner of utterances will be made. It will engage all of us for the next 2 months until the contest is held. It is the reality, I can only describe it as a reality, which is the reality presented by the petitioner. Kenyans will be treated to the political jargon that we are now accustomed to. Attorney General reminds me, vifaranga via computer is one slogan.
Doing that as an amicus.
Let me speak for myself, my lord. My lord and colleague sought to know from me whether I knew of any of this. I made no answer because I didn't. But he took the liberty of a man in mid-speech.
Take care, Mr. Attorney General. At least you find yourself being classified as partisan.
No, it was with a light touch, my lord. and all that is taken in good standing. There is nothing derogatory about it in my submission. A quick rejoinder is made by the other parties. We need not go to that. But all that is the rhetoric, unhealthy rhetoric in an electoral contest. Compare that, my lord, or before we compare it, let's still look at this reality and what it presents. It presents that this nation will have to contend with another presidential election. With all the invasive aspects of a presidential election. My lords, we are trained in such a way that we can make that reality look like a legal contest. A legal contest like we are advancing the rule of law. We are not really here advancing the rule of law. We are advancing an opportunity for an electoral contest. The other reality presented by the third respondent is this, my lord. To allow the third respondent move on with constituting a government, he has offered a hand of fellowship to the petitioner, offered a hand of fellowship to all Kenyans, that it is time to go back to nation building of this great nation. I paraphrase, without the eloquence of the third respondent, that the time of elections are over. Let us go back to building this nation. If given that opportunity by this honorable court, what I look for or look forward to is an inclusive government where each and all Kenyans will be participants. That is the reality that I'll urge this honorable court to find favor with, because we cannot be in an electoral mode throughout our lives. There is no guarantee, my lords, absolutely none, that even if we were to hold another round of elections, those minuscule errors or by clerks will not take place. They will still take place. But those errors are so insignificant that they do not affect the result of any outcome. I conclude my submissions. Yes, I am told by my assistants, my lords, that as regards, there was a complaint about there being such a big difference between the people who voted in presidential elections as compared to people who voted for the other elections. Before we play the video, let me say this, that we have in the affidavit of Davis Shishil demonstrated that there are indeed peculiar Kenyan habits, even in voting. In certain areas, and we have identified 94 areas, you will find that the outcome at one election was so high as compared to all the others. And that is nothing more than that the people in that area were, in all probability, voting for one candidate who was their favorite candidate. Say, for example, a member of parliament may get more votes in that area, more than even the governor or the president. Which one? Number two, before we play the video, is to show, my lords, that if you compare Jubilee Party election results for the post of governor or the post of senator or woman rep, members of parliament, you see that in all of them, the results are in the region of 53 to 60%. 53 to 60%. Okay. Now we'll show a short clip and then I'll be concluding. Yes, it won't take long.
Okay. It's not a clip. It's just a video. So for the presidential, that is what we have. Our client had 54.3%. Then we go down to the gubernatorial. He had 53.2%. And the next one is now the pattern. The one marked red represents Jubilee. We can see that it is more than half of the map of Kenya. And that explains the number of governors. Jubilee has 25 seats. We have KANU, which is an affiliate party, which has 1. That takes it to 26 seats. Way down to the Senate election results, we find that Jubilee Party has got 51.1%. The Senate election results, Jubilee, the voting pattern is as shaded, representing the 51%. Parliamentary election results, we find that the Jubilee Party has 48.6%, together with other affiliated parties as shown. Then we go to that is the total number of the positions. We go to the women representative. At the women representative, we have Jubilee having 55.3%. The voting pattern is shown. Then finally, that is it. Thank you. Thank you.
So, my lords, from all those results, and these are 6 elections held the same day, you will see, my lords, that the result for the president is not dissimilar, and that is the point I wanted to make, it's not dissimilar from the results in the other 5 elections. As a matter of fact, one would say they all follow within the same range. So any aspect about votes being added, votes being deducted, it's really not scientific, it has no basis, and it's yet another allegation, which is a red herring. I therefore conclude, my lords. I started from a constitutional argument point of view because in my submission, a contest regarding presidential petition or presidential outcome ought to be litigated within the confines of the Constitution at the very least, or bearing those articles in mind at all times. And in my submission, the quantitative test is at the highest level. Highest in the sense that one must gain not less than 1/2 of the votes cast. That is unique to the presidential results. It's not similar to the other 5 results. In the other results, actually one who has even 21% or 20% or whatever percent could be declared the winner. Number 2, my lords, having demonstrated that elections were held within the expectation of the Constitution, it will be unfair, in my submission, to invalidate them for infractions which in factions we have demonstrated do not exist. And finally, my lords, that as regards the accusations against state officers, those allegations are without any basis whatsoever. They were not pleaded in the petition, and they cannot be, so to speak, added at the tail end of the hearing of this petition. My lords, my learned friend, Mr. Ahmed Nasir, will now conclude all the submissions that we have made.
My Lord Chief Justice and Judge of the Supreme Court, I think one document we should have really highlighted right from the start, but what we didn't do, was the affidavit, my Lord, by the third respondent. And I would just like, very briefly, my Lord, just to refer you to paragraph 7. So that gives you the best image, and it's a pretty image. Have you given everybody? It's the best, but so that, my Lord, it gives you an image of how sweeping the victory of both the third respondent, his party was in all the 6 elections. And my Lord, if you look at paragraph 7, you can see page 2, everything red belongs to the third respondent. If you turn the next page, my learned friend has shown you the video, but this one provides a better picture so that you can really see how sweeping it is. If you look at page 3, my Lord, it is the governors. Then you can see the Senate again in red at page 4. Then you can see women representative. It is slightly even more when you come to women in time of how Jubilee was women-friendly. And then at page 6, my Lord, is the National Assembly, my Lord. So, my Lord, I think that's the point my learned friend emphasized, that there was nothing ordinary. It was not a case where the respondent wins the presidential election and he has 10 members of parliament. No. I mean, my Lord, Jubilee has the largest number of a single party since multi-party democracy was introduced in 1992. Its victory was that sweeping. My Lord, there is an issue raised by the petitioner in relation to Section 83 of the Election Act, the one that talks about non-compliance with the law, which says, my Lord, that no election shall be declared void by any reason of non-compliance with any written law, as long as that non-compliance, as long as the election was conducted in accordance with the principles laid down in the Constitution. And I'm emphasizing the principles laid down in the Constitution. My Lord, Chief Justice, it's not in dispute that when it comes to a presidential election, the constitutional regime that regulates a presidential election is very distinct and defined in the Constitution. And my learned friend rightly emphasized that point. And my Lord, the constitutional regime for how a presidential election is conducted is found in Article 138. So, my Lords, the principles referred to in Section 83 of the Election Acts are those principles that are captured in Article 138. And what are those? There are 4 principles, my Lord. 1, all registered voters must have an opportunity to vote, or all those who are entitled to vote. Secondly, my Lord, is that secret ballot. The election must be secret ballot. That's the principle. For example, if the election was Mololongo, or if there were law instead of a secret ballot, it will be in breach of the constitutional principles. The third one, my Lord, is that the votes must be counted in the polling stations, and IEBC shall tally and verify and count the result and declare. And lastly, the candidate shall be elected president when he wins 50+1. Those are the constitutional principles, my Lord, that Section 83 envisage or holds to in a presidential election. My Lord, the other point is, and I think my learned friends for ABC captured it very well, is that this allegation of disparity between the presidential election, in other words, more people voted for the president than other candidates. And my lords and my lady, I will just very briefly draw your kind attention to the affidavit of Winnie Guchu. And my lord, if you look at page 36 or paragraph 88 of that affidavit, we analyze 94 constituencies where other positions other than the president got the highest vote. And even in Kiambu itself, in several constituencies, the voters gave more votes to the women representative than the president himself. And we have given the list in paragraph 88. Even in my learned friend's constituency, he got more votes. The governor was the most competitive seat. So it depends from one region to another. There are certain places, for example, where, if you look at that page 36, Kibwezi East, the senator was the most competitive. If you look at Voi, the senator was the most competitive. If you look at Molo, the parliamentary seat was the most competitive. If you look at Rongo, the governor was the most competitive. So, my lord, as they say, all politics is local. That is what determined which was the most competitive. Lastly, but not the least, if you look at Starehe, the woman representative was the most competitive seat in that election.
Mr. Nasir, if I understand the argument well, is that the votes cast, the total votes cast for the president were more than those cast for the governors, for example, for the women representative, for example. It's not a question of a president getting more than the governor or what?
We have done the total, my lord, yes. But, and I think IEPC, Mr. Somane, explained it very well. But even when you do that, it's not necessarily true, or the difference was very insignificant. My learned friend will explain that quickly. But my lord, finally, it's my submission, my lord, that the petitioners have not discharged the burden of proof. That burden, my lord, because it has not been discharged, at no point during this trial did that burden shift to the third respondent. But my lord, that notwithstanding, and out of abundant caution, that suspender and belt approach, my learned friend has taken you through each and every allegation they have made, not to prove, but to show, my lord, that all those allegations were false, whether it's in relation to ungazetted polling station, whether it is in relation to the disparity between the presidential and electoral offices, and, my lord, any other averments that's contained in the petition. So, my lords, it's the prayer of the third respondent that, in light of the failure on the part of the petitioners to discharge the burden of proof, this petition should be dismissed with cost. And I pray that it be satisfied for two counsel.
My Lord, we will always spend just a few of our time. One is to answer, my Lord Chief Justice. There is no legal obligation on any voter to vote in all the 6 elections. True enough, you are given 6 ballots. You are given 6 ballots, but there is no corresponding obligation that you must vote for all the 6. So you see in certain areas, and we have done a mathematical analysis, in certain areas you find almost a huge number of people voted for president, and say senator, and for governor, there was very little voting. And those are some peculiar habits of our voters. Yes. So in absence of a legal obligation, so there are some ballots really that do not count. My lords, there is an issue that was raised by Senior Counsel Mr. Orengo yesterday, Senator Orengo, about barcodes, that some documents don't have a barcode. I had not anticipated that in the written submissions. Allow me to answer it in these submissions because it wasn't in their written submissions, about absence of barcode in certain of the forms.
Mr. Ngata, just before you leave the question that voter is not obliged to vote for the 6th candidate.
Yes.
That is the position.
Sorry?
That will not be the position.
About a legal obligation.
A voter can vote for one candidate and not for the others. That's what you've told us.
I am meaning a compelling obligation that you must tick. You are given the 6 ballots, you are given a place to go and vote, and since there isn't a compelling force, that's what I meant.
You're saying the same thing?
Oh, very good. Thank you.
My question is,
yes,
how are the other ballot papers accounted for? Because at the point of getting the ballot paper, a voter gets 6, correct?
Yes.
And they choose to vote for MCA and not for anybody else, right?
True.
So what is the name given to the other ballot papers? For the president, is it spelled? Is it stray?
Yes.
Is it rejected? What is it?
I wanted to handle those two, or one of my colleagues to handle those two together. That's why I was explaining the point, the point of the barcode raised by Senator Orengo and the question by my Lord Chief Justice, and invite one of my colleagues, Mr. Masharia, to answer both within a relatively short period of time.
Thank you very much, my lords and my lady. I deal first with the question of the barcode that was raised. And the first... I deal first with the question of the barcode. The barcode was not an issue raised in the petition to begin with, but having been raised, this is the explanation. Number one, the format of the forms prescribed under the election general regulations does not require a barcode. The format of that particular form, that's number one. Secondly, that barcode, as we are made to understand, was limited to Form 34B. Thirdly, it was not in the prescribed requirements that the IBC sent to the printer. It was an innovation originating from the printer themselves as surplusage. That's number three. Number four, the question was one, and this was dealt with at the scrutiny which I attended yesterday night. It was the question of using the wrong reader. So that if you used your phone, and everybody has some of these phones sometimes, you came up with a different result. That was the fourth response to that particular issue of the barcode. And so the issue raised here is really a red herring as refers to that barcode. And fifthly, these were the same forms transmitted to the National Tallying Center and inspected by all parties prior to the declaration on the 11th. But to come back to the question your ladyship asks about the 6 ballot papers, it is indeed correct that the format of voting is that you're given all 6 votes, and you walk into your booth and you take them. Now, the regulations, however, make provision for an item known as a stray ballot. There are many ballots that end up in the wrong ballot box. The regulations call them stray ballots. These are to be distinguished from a rejected ballot from a spoiled ballot. The same regulations require that the presidential election be counted first. And so that by the time the results are being streamed onto our screens and being counted, all the other stray ballots have not yet been counted because they're in the other boxes.
Mr. Macharia.
Yes, Your Ladyship.
You're making the assumption that the voter votes for whatever candidate it is they want.
Yes.
And when putting, and that's an assumption.
Yes.
When putting their ballot box in their ballot papers in the box
Yes.
for the candidate they have voted for,
Yes.
they would put all 6?
No.
That's the only way
Yes.
a stray ballot would arise. A stray ballot is one
Yes.
which is put in the wrong box.
Correct.
So even though it is correctly marked,
Yes.
it is dropped in the wrong box.
Correct.
My question is this.
Yes.
Where a candidate, where a voter collects the 6 ballots,
Yes.
because the assumption is we will be given all 6.
Yes, you're given all 6.
And you want to vote for only one candidate.
Yes.
Where do the other 5 ballot papers go? It's a very simple question.
That's what I answered, Your Ladyship. That the law, and I think the regulations actually make it quite clear, that even having been given the 6, and even with the color coding that the ballot boxes have and the ballots themselves have, room is still created for what Your Ladyship correctly called the stray ballot, which is a correct ballot placed in the wrong box. Now, when you look at the regulations and you retire to do your ruling, you will find that those stray ballots are kept in a separate envelope by themselves, according to the rules. Yes.
Mr. Macharia?
Yes, my lord.
You are still not answering the question.
Yes.
You walk into a polling booth.
Yes.
You're given 6 ballot papers.
Yes.
So you decide, as you may decide,
yes,
that you'll only vote for a presidential candidate.
Correct.
That leaves you with 5.
Yes.
Those 5
yes.
are not stray.
No.
They are unused.
Yes.
You've been given 6,
yes,
but you have elected to use only 1.
Yes.
That leaves you with 5.
Yes.
What we are asking,
yes,
where do those 5 go? How are they accounted for? It's a simple question.
Oh, yes.
They're not stray.
No, they're not stray.
They can only be stray if they have found themselves through in the wrong ballot box.
And that's the point.
Okay. So they're not stray. So you still remain with 5.
Yes.
Where do you put them? You carry them away?
No, 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 no.
How are they accounted for?
No, and that's the point I'm making. You vote. You vote for 1, and vote for the 2nd, and vote for the 3rd. You have 6. Yes. You tip all of them, and then you go. Yes. Let me explain again, as I understand the process.
Order. Order, please.
I could allow one of my colleagues from IBC to do it, but I could. They are more conversant with that process, but yes, yes.
Please, my lord. The question that the court poses, my lord, the simple answer is this. There is a need, when you're given 6 ballot papers, you need to mark each and every one of those papers with your choice of the person that you're voting for. If, however, you elect to only vote for one person, the other ballot papers which do not indicate who you've chosen to vote for, If they are still put in the box, at the point of counting, because you have not indicated who it is that you are voting for, becomes a rejected ballot. So that's a rejected ballot, because it has not indicated who it is that you voted for. So among the rejected ballots, you will find the difference between the two. Because the purpose of a ballot is to indicate who you voted for. So if you don't indicate, it will most likely still be put in the ballot box, but since it will not have indicated who you voted for, it becomes a rejected ballot, not a stray one.
Very well. Okay, wind up, Mr.
And so, yes, my lord, and so that was the explanation for that one. The final point I think we wanted to make was a question raised by our colleagues and brothers from the petitioners with the question of the votes for Nyando. That question, your ladyships and my lords, is dealt with in the affidavit of Winnie Gosho, and these were the 60,000 votes that my colleagues said were missed out of the Form 34C. The proviso to Regulation 87, Subregulation 4, entitled the second respondent, where the difference in votes not yet arrived, does not make a difference to still declare the result. The exact percentage of that vote from Nyando in Kisumu, sorry? Regulation 87. There's a proviso. This is the proviso to Regulation 87, Subregulation 4. The exact percentage difference that Nyando made, and it still counted, was 0.39% of that vote. And so the second respondent was entitled to do so. I end by calling your attention to an accusation made against the third respondent on the question of the President's delivery unit, or what's known as the delivery portal. Again, your ladyship and my lords, I call your attention to the affidavit of a gentleman known as Andrew Wakahio, signed and sworn in response to the affidavits of Dr. Nyangasi Oduwo and Olga Karani, and to paragraphs 100 to 120 or so of the affidavits of Winnie Gosho, and to the constitutional provisions set out therein as regards the duty of government to account and to deliver information to its people in a timely manner as to how it's spending their money and to what it is doing. Unless my lords and your ladyships have any further questions for us, we reiterate our plea to you to dismiss this petition and to do so with costs. Thank you very much.
Just a clarification. Both Mr. Gatia and Mr. Ahmed Nasir, you described what we last watched on the screen as a video. For the record, I don't think that is the description. Perhaps you are gray-haired and perhaps not .com. Perhaps the .com member of your team can properly describe what is it that was presented for the record.
That was
we offer the girl.
That was the graphical representation of the votes cast in all the positions that were sought for elections on the 8th of August. It was a graphical presentation.
And lady, that's why I safely referred you to the affidavit of the third respondent.
Mr. Ngatia, Mr. Benasir, Mr. Omogeni raised one question yesterday about Section 23 of the Leadership and Integrity Act, and he asked the court to declare that section unconstitutional. Would you like to address us on that? Because we won't have another chance.
Yes. Number one, my lord, that is not a request in the petition. Nowhere in the petition would you find a request like that. Number two, being a contestation regarding an act of parliament, it ought to originate at the High Court. It can't originate from the bar at the Supreme Court. It is one of the matters that ought to be litigated under Article 165, and it should be done in the... So without any exchange of pleadings, Omogeni, with all due respect, I think, was making a barb at it. It wasn't a serious request.
My Lord, can I just add one point that, I mean, a petition under Article 140 is a single subject issue. You are to determine whether the third respondent was validly elected or not. Unless, but my learned friend's reasons whether that section 23 is unconstitutional or not really does not fall within the confines or the contours of this case.
Thank you.
Okay, very well. We will adjourn and come back at... sorry? Yeah, Mr. Rango?
Yes, my lords, when you made the order that judiciary staff be increased to undertake the process of scrutiny, we had a word with the registrar just outside, together with, in the presence of my learned friends, Mr. Mwite and Mr. Karori. And he was telling us, yes, they have added staff, but now the challenge is that the agents, because the parties were restricted to 2 agents per party, by every party to this petition. So they cannot be able to execute that work as quickly as possible. And we thought that if the court could allow each party to have an extra 3 agents, then the work would go faster. In fact, from the registrar, he was saying he could even upscale it to 200 members of staff of the judiciary to undertake that exercise. But I must say from the bar, since that time, there's been a lot of improvement in the work that is going on, at least from our perspective.
What is the view of the other parties? Increasing the representatives to speed up the work?
Lord, I will indicate that in a moment, but can I also clarify that as far as the access is concerned, that has been resolved and the petitioner has been given access, and I think that the registrar of this honorable court should be able to bring a report within the timelines that the court gave. Access has been given. So that leaves us only with the issue of Forms 34As and Forms 34B.
Yes.
And because of your lordship's directions that the staff be increased, the staff were increased, but now because of that increase in staff, perhaps the parties should be given the opportunity to be represented by slightly more agents. And I think
about how many?
Five as suggested is good. Your lordship also asked a question, her leadership, the deputy president, on this unmarked. What happens to the 5 ballot papers if a voter decides to vote for only one candidate? And with your permission, I would wish my friend Karoli Kamau to perhaps draw the attention of the court. Sorry? To a regulation section.
Yes, ladies, I think it's important to just show that even the regulations envisage the situation where a voter might not mark the paper. And Regulation 77, which deals with rejection of ballot papers, says that at the counting of votes at an election, any ballot paper, E, that is unmarked, shall, subject to subregulation 2, be void and shall not be counted. So even the regulations envisage the possibility that a voter might not mark a ballot paper, and therefore that ballot paper shall be rejected and shall not be counted. So it actually envisages it.
Okay. Yes. Okay. By consent of all the parties, we will vary our order 4 to allow each party to have 5 representatives. Is that okay, Mr. Orengo?
Yes.
That's okay, Mr. Muite?
Yes, it is. I don't know about this.
To speed up the
third respondent, I don't know what their views are. Yeah.
To speed up the process?
Yeah, we have no difficulty with that. It's good. It's fine.
That's fine. Okay, then we will adjourn for an hour. Come back at 3:30 and start with the interested party. You have 5 minutes. I thought, Mr. Kinyanjui, after lunch you can condense it to 5. Okay, 20 minutes. 20 minutes, and then we will proceed. Thank you.